Hi, I'm Dr. Ofer Lecture, and I specialize in intellectual property law. In this session, I'll talk with you about patent law in some detail and also say a few words about trade secrets. Patents are one of the most important IP rights. They protect new technological inventions. The owner of a patent can prevent others from making, using, or selling the invention. Why do we protect technological inventions with patents? The most common explanation focuses on the need to encourage innovation. Without a patent, other people could freely imitate the technology, and inventors would not be able to make sufficient profits and may refrain from pursuing innovative projects to start with. Patents could be a solution to this problem. Another role of patents is to promote the disclosure and dissemination of new technological information. To understand how they do that, we need to take a quick look at the process of obtaining patent protection. An invention must be approved and registered as a patent in order to be protected. Absent registration, no patent protection. The first step towards patent protection is the filing of a patent application with the Patent Office. If two patent applications submitted by different people are for the same invention, a patent will be awarded to the first to file. Clearly then, the timing of filing matters. Not too early, because one needs to have an invention that meets the standards for protection, but not too late, so that one doesn't lose priority. As part of a patent application, the inventor must disclose the details of the invention and how it is different from the existing technology in the field, which is called, in legal jargon, the prior art. The disclosure needs to be rather detailed and often includes drawings. For example, take a look at the drawings that Thomas Edison had to include in his patent application for the first electric lamp. The patent registry is public, which means that at some point in the process, the details of the invention are made available to the public. This allows others who wish to enter the field to check whether they are stepping on an existing patent. This check is called a freedom to operate analysis and is very important for technological entrepreneurs. Sometime after its filing, a patent application goes through an examination in the Patent Office. The examiner checks whether the invention deserves a patent. You probably ask now, what are the conditions? So first, the invention needs to be in a technological field. These fields include, for example, medical technology, pharmaceuticals, biotechnology, nanotechnology, information communication, computers, chemistry, mechanical engineering, and electricity. Generally, abstract science cannot be patented. The invention must have an industrial application. A patented invention can be a product, for example, a new drug, Edison's electric lamp that we've just looked at, a new microprocessor, or post-it notes. Patents can also be granted for new processes, for example, a new method of manufacturing a certain material or product. Note that patents are available not just for breakthrough inventions, but also for more minor inventions that make small improvements over existing technologies. One other main condition for patentability is novelty. In other terms, to get a patent, the invention must be new. Novelty is examined against everything that is known in the entire world. So if someone files a patent application in Israel and it appears that a similar patent application was previously filed and published in Brazil, or a scientific paper that describes the invention was published in China, the invention is not considered new. Note that the applicant itself may risk the patent by publicly disclosing the invention too early, meaning before filing. So remember, if you invent something and consider patenting it, you should not disclose it before submitting your application. If you find it necessary to disclose information before filing, for example, to potential investors, this should be done under confidentiality agreements. One other important condition for patentability is that the invention must not be obvious. It has to reflect a step forward from existing technology that would not seem obvious to someone skilled in the relevant field at the time the application was filed. So assuming we meet all these conditions and complete the registration process, we get a patent. What exactly does this mean? As I said before, a patent provides its owner exclusive rights over the invention. Others are not allowed to make, sell, or use the invention without the patent owner's permission. The protection is strong and applies not only against copiers, but also against someone who independently developed a similar invention without knowing that it infringes a patent. Patent exclusivity only applies in the territory where the patent was registered. The inventor must file a patent application in every territory where she wants protection. Patent protection is for a limited time, generally 20 years from the filing date. Once the patent expires, the invention enters the public domain and everyone can use it. Patent law includes certain exceptions and limitations on the owner's rights. For example, some countries allow uses of patented inventions for research purposes under certain circumstances. Aside from patents, one other way to protect technology from being used by competitors is to keep it secret. Let's focus on trade secrets for a few minutes. To remind you, the way patent law works is that the inventor must disclose her invention in return for legal protection that lasts 20 years. When one chooses secrecy over disclosure, there's a chance of keeping the secret for a longer period of time, which is one of the main reasons why some entrepreneurs decide to take the chance. An example that is often given for a successful reliance on secrecy is the formula for making Coca-Cola, which was never patented by the company but rather kept as a secret for many years. But not every invention can be successfully kept secret after the product enters the market. In many cases, once the product is out there, competitors can analyze it and figure out how to make it quite rapidly. It is important to note that even when someone does not file for patent protection, but rather keeps an invention secret, the law may provide some protection by what is often called trade secrecy law. Not only technologies could be protected as trade secrets, but many other pieces of information such as business plans or client lists. The definition of what counts as a trade secret varies between different countries, but often one of the conditions for protection is that the owner of the secret takes reasonable measures to keep it secret. For example, by technological protection measures, limitations on physical access, and legal agreements. Trade secrecy protection is, of course, much humbler than patent protection. Trade secrecy law doesn't guarantee exclusivity, but merely protects against unlawful takings of the secret. We now move to a different type of intellectual property protection: copyright.